right. Good afternoon, everyone. Thank you for joining us for the second series of the Michigan Defense Trial Council's virtual winter meeting. My name is Javon David, and I'm an attorney at Butzel Long. It is my pleasure to serve as the moderator today, alongside Edward Perdue of the Perdue Law Group. As many of you know, the Michigan Defense Trial Council, or MDTC, is an association of leading lawyers in Michigan dedicated to representing individuals and corporations in civil litigation. We have a great session here for you today. First, attorney Mike Weston of Lederer, Weston, and Craig, located in Iowa, will present on effective advocacy in his presentation entitled Be Your Best Advocate, 10 or So Tips to Improve Your Performance at Trial. Just a bit of background information on Mr. Weston. He is a founding member of Lederer, Weston, Craig in Iowa. He is a fellow of the American College of Trial Lawyers, a member of the Federation of Defense and Corporate Counsel, the International Association of Defense and Corporate Counsel, the Association of Defense Trial Attorneys, and the Iowa Academy of Trial Lawyers. Mr. Weston has been recognized by Chamber USA for Business as one of only 2 Iowa lawyers given a Band 1 title, which is the highest rating in insurance litigation. He has also been recognized as a Great Plains and Iowa super lawyer. After Mr. Weston's session, you'll hear from a panel of 3 judges regarding their experiences on the bench and suggestions for effectively presenting your case at trial. Joining us today is Judge David Allen of Wayne County Circuit Court, Judge James Jamo of Ingham County Circuit Court, and Judge Curt Benson of Kent County Circuit Court. Just a couple housekeeping matters before we begin. If you have any questions for the panelists, please place them in the Q&A box. We will save time for questions at the end of each presentation. In addition, in the chat box, you will find a link to register for the 3rd session of the MDTC virtual winter meeting, which is being held on December 4th from 12 to 1:30 p.m. The chat box also includes a link to view the 1st session of the winter meeting in case you missed it. So let's begin. Mike, go ahead and take it away for us.
Well, thank you, Javon, very much. I am happy to be with you today. Let me see if I can make this happen. Let's see here. I need to open this. Can you see my slideshow?
Yes.
Okay. Well, good morning from Iowa, everyone, and good afternoon in Michigan. I wish I was with you in a beautiful state that you are. People always ask me, tell me about Iowa, and I always tell them that Iowa is the state that prevents you from falling into the abyss that is Nebraska as you walk across the Mississippi River to the west. So always be thankful for Iowa. Today, I'm going to spend 40 minutes or so talking to you about how to try cases a little bit better. Whenever I listen to a presentation like this, I'm always struck with how many times have I heard the same materials over and over, and much of what you hear from me today, you have heard before. But I find that repetition is good, and maybe you'll pick up something from me or the way I say something that will help you be a better advocate and a better trial lawyer as you go forward. My first tip, be yourself. And I think this is a good advice, not only for you as a trial lawyer, but for you as a lawyer generally. And I'm going to suggest to you there are 2 kinds of people in the world. There are Dustin Hoffmans and there are Kevin Costners. And you need to understand which of the 2 that you are and use who you are as well as you can. What do I mean by that? Some of us, like Dustin Hoffman, are able to very well play all manner of roles. They can be happy and be effective. They can be sad and be effective. They can be angry and effective. They can modulate their voice and be effective. They just have that it that allows you to kind of be different before different audiences in different situations. Not everyone has that talent. And so if you're a person who if you're a Dustin Hoffman, I encourage you to use your gifts in the courtroom and as an advocate in all aspects of your practice. Use the drama that you can bring to a situation. Use levity that you can bring to a situation, and use those all to your advantage. But if you're Kevin Costner, and if anyone is related to Kevin Costner on the phone, I'm not being demeaning. Kevin Costner, A, is a very successful actor, and B, he made the most important movie in the history of film, Field of Dreams, as you know, which was filmed here in Dyersville, Iowa. But Kevin Costner typically plays Kevin Costner in almost every role that you see. We've all run into lawyers who every time we see them, they're grouchy. Every time we see them, they're happy, but they tend to be the same. There's nothing wrong with that. It's predictable, it's certain, and you can build things off of that. But if you're Kevin Costner, don't try to be Dustin Hoffman. We always hear the advice, don't try to be funny in the courtroom. Well, I would amend that to say, try to be funny in the courtroom if you're Kevin Costner. Try to be funny in the courtroom if you're Dustin Hoffman, because then you'll know how to do it and do it effectively. So my first tip to you is to be yourself, know yourself, and use it to your advantage. My second tip is to be Al Kaline. Now, you don't know this about me, but I'm a Detroit Tiger fan. It's been hard of late, but when I grew up, I used to listen to WJR radio and the great Ernie Harwell. And I remember how disappointed I was in 1967 as a kid that we got down to the last weekend of the season, and I think, as I remember, we lost a game to the Twins, or we were battling the Twins and lost the second game of a doubleheader and didn't win in 67, but of course won in 68 and 84. Now, why do I say be Al Kaline? Because you are on trial every time you step into a courtroom. And when you step into the courtroom, you have to be Al Kaline, total confidence. Al Kaline was the kind of baseball player who played right field, and today it would be Mookie Betts if you're younger, who plays for the Dodgers. Al Kaline was the kind of right fielder who, when the ball was hit there in the air, the pitcher didn't have to turn and look. Why? Because Al Kaline was so effective as a right fielder, they knew that the ball was going to be caught. That's why he got 10 what are called gold gloves for being such an effective right fielder. So be Al Kaline in the courtroom. What do I mean by that? Why is it important? 55% of jurors, according to a survey I read recently, remember how you look. And I remember one time after a trial asking the jurors, as we all do, we can in Iowa anyway, what did you think about the trial? What questions do you have? And they said, why did your opponent, the plaintiff's counsel, wear Argyle socks with a suit? Now, frankly, I probably had done that before, but that just shows you the extent to which the jurors who sit there for hours upon hours focus on us as the lawyers, and they remember how you look. The next most important is they remember your body language. They watch how you stand and you sit. They watch your facial expressions. So that's why you have to be confident in the courtroom. That's why you have to be Al Kaline. And you have to do that in everything you do. Your counsel table should be neat and orderly. Why? Neat and orderly people exude confidence. You need to be calm in the courtroom. Nothing surprises you. Even if you have bombshell after bombshell dropped on you, you have to be completely calm. I have actually taught myself over the years to do two things in trial that I've been doing for years. The one is when I take notes, I just never change my expression as I take notes, and I never take notes right after I've been hit with something that I didn't anticipate. And the other thing I try to do is during the argument in the case, both the opening and the closing, I sit there quietly and just listen. I try not to make a facial expression. I try not to type or write furiously. I just try to be calm. So do that. Try to think about how you act and react in the courtroom and what will exude the most confidence to the jury. And remember, everything you say to the jury has to be spot on, has to be on the mark. You are the reliable person in the courtroom. You're going to help them make the decisions they have to make. to serve as jurors. Next, assess your case early and often. As we get, and why does this matter to the trial practice? Because trying cases is all about identifying the best way to present the information you want to present to get the decision that you want. And I think we get so caught up in cases, especially complex cases, with discovery and motions and reporting to the client and billing and all the things that lawyers do before we get to trial, that we forget to focus on the things that will bring us success in the courtroom. So what I try to do early on in a case is write statements. And I try to do that. I try to return to them during the course of the defense of a case, and I try to expand on them. But I write 3 simple sentences, and I do it in every case, and I do it early on. We will win this case because, fill in the blank. We will lose this case because, fill in the blank. The case can go either way depending upon these facts. Simple proclamations that you can return to that are your anchors to the way that you're going to try to present the case and understanding how the other side's going to respond. They make you focus, and ultimately at trial, they will become your themes. You won't have to, before the trial, think what will be the most effective. And as the case progresses, expand your list of we will win the case because from 1 to 2 to 3, as many as 5, and for the other categories. Use them throughout the case, return to them throughout the case, modify them throughout the case so that you're focused in all aspects of the defense and you're focused at trial. Next, fight the reptile. There are more articles and webinars than you can shake a stick at that talk to us about how to fight the reptile brain argument. But even out in Iowa, lawyers who are not very skilled have adopted the reptile brain principles in taking depositions, in trying cases. And quite frankly, they're pretty effective. The jury verdicts, since these principles and tactics have come to Iowa, have gone up significantly. We've had our first 8-figure verdicts in bodily injury and death cases in Iowa. And you all know the reptile brain basically preys on, or allegedly preys on that part of the brain that's concerned for a person's safety. It's the golden rule that the community's safety is their safety, and their decision in the case affects them personally. And because of that, and I'm going to leave it to you to educate yourself as to the tactics themselves, but they basically involve getting witnesses to testify about safety standards and protecting the public as opposed to the facts of a case. You have to prepare your witnesses for this tactic. Don't allow reptile questioning and depositions when questions like, you would agree the number one goal at your company is safety. You would agree that safety at your company protects the public. You would agree, on and on and on, the kinds of things that make it sound like the case is about general principles versus the facts. And teach your witnesses to say that they don't agree with those. Teach your witnesses to say that they need more specificity. All of the things that we're taught to fight those. You have to employ those tactics, and you have to employ them at trial. Use motions in limine to fight their use at trial. I have a federal court case going to trial in December. Against me is a plaintiff's firm that uses these tactics very well. And we filed our motion in limine, and it was sustained. And the plaintiffs are going to be very limited in the way that they can use reptile tactics at trial. The other thing is beware of try to use the honey badger, the defense reptile tactics. What are some of the things you can use to fight the reptile? You can implant in the jury's mind the notion that accusing someone of something serious deserves serious proof, that unpopular defendants deserve fair treatment. And if the case was only about sympathy and general standards, we wouldn't need a trial. And there are a multitude of articles out there about defense honey badger or anti-reptile tactics that I would encourage you to use, but it's a real tactic and one that you have to take seriously at trial. Next tip, know your client well. I really don't think, I think when we get cases, especially cases where our client is a corporate client or a business client, I don't think as defense lawyers as a group that we do enough outside of our contact with them to understand and know them as the public knows them. And so I would encourage you early on in your representation of a corporation to learn about that corporation and to understand them. It doesn't take a lot of time, but there's so much material that's available out there that you will understand the way the jury looks at your client by knowing them better. How do you do that? First of all, within the company, you need to know early on what person in the chain of command of the development of a product, for example, or the sale of a product, or the purveyance of a service, who cares about the outcome? In other words, what person in the corporation may have their world changed by the decision in the case? Those people are your allies as you work on a case. And they will also give you the time that you need to well defend the case. They'll give you better service as a 30B6 witness. They will get you to the person who was involved in creating the warning for a product. They will take the time internally to help you, whereas others who don't care as much, who may have a title, but their job is not affected, may not. And you all know how important it is when you decide who the face of the corporation will be at trial. That's something that you have to discuss early on, and that person needs to be cultivated and understand their role at the trial. And of course, you have to know who's going to be given the key evidence and testimony in the case so that you'll understand how the story will come out from the perspective of your client. The other thing then outside of the entity is you need to do your research about the company. Their reputation is critical, and online research is critical. A good source, of course, if they provide a service in your area, are things like Google reviews, where you can see what real life people who may be on your jury think about your client. Are they an employer in your area or in the area of the venue of the court? What is their reputation as an employer? If it's a union shop, have there been strikes? Have there been union unrest? Has there been a lot of turnover? You need to understand that. If they have a home office or significant branch in the venue of the court, how are they perceived in the community? Are they involved in charitable activities in the community? Are there executives out in the community serving on boards, commissions, the kinds of things that would ingratiate them to a jury? And do they care about the outcome? Are there been other cases like yours where they've gotten bad publicity, where they've maybe changed in response to a problem or issue with the company? All of those things are available online for you, and I would encourage you to understand your corporation or corporate client as well as you can. Next, pick the right jury. I don't think you have unlimited voir dire in Michigan, from what I could tell before this this presentation. I know you don't in your federal courts. In Iowa, we have almost what I call Texas-style voir dire. So we have pretty wide open attorney questioning of the panel before the jury is selected. So some of the things I'm going to talk about when I talk about closing argument are themes that I develop in kind of a open attorney conducted voir dire. But in jurisdictions where you don't, how do you pick the right jury? Well, one thing you do is you go back to your declarations that you wrote about we will win this case because, we will lose this case because. And once you see who the prospective jurors are, think about how they'll respond to your declarations, because that will focus you on your themes and how those themes might resonate with the jurors that are in the box before the panel is selected. The second is know the jurors as well as you can. Use jury question information, search social media. You've heard that 100 times before, but I would encourage you to do that. And it's something that a good staff person in your office, or maybe one of your kids who's in college that wants to make some extra money, can probably help you with. Make certain that you only, though, go to public sites. Don't try to do anything to go beyond what any person on the internet could find. Now, if you don't know anything, one of the things we do in Iowa, because no one's got an office in Iowa, so I'm local counsel a lot. And so when people ask me, tell me about juries in Iowa, tell me about individual jurors, I will always tell you that there are two things that universally will tell you the most about a juror. The first is their age, because their age tells you what was going on in their lives during the formative years, which I consider to be 15 to 25, when they were transitioning from high school, college, taking on a craft, taking on a career, when they were making their first financial decisions in their life, when they were first impacted by managing their own finances, running a household. The things that are happening during that period, I think, are imprinted on us, and they certainly change us, but they cause us to look at the world through the prism of those events. And we tend to return to those. And I've given you some examples for those who are my age, and I did not serve in Vietnam. I was just a little bit too young, but the Vietnam War in the 60s and early 70s was an incredible time, a very divisive time in the country, a very controversial issue. And so people that are in their late 50s and 60s will always remember that event, and it forms thoughts about the way you look at government and the military and all sorts of different things, versus someone who is 20 or 22 today, like two of my kids are, going through the horrible COVID pandemic, and how they will look at healthcare in the future and the management of health situations and the role of government. And you can really look at any period of time, and those formative years are important. So one of the things that you want to think about when you look at a 50-year-old woman who's sitting on the jury, you might think, okay, that person was at that stage in the 80s. What was going on in the 80s? What's her view of the world? Those kinds of things. The second most important thing is an address. And I always say this: you can lie with clothes, you can lie with cars, you can lie with toys, you can lie with the vacations that you take and all sorts of things. But most people live where they're comfortable. Most people live where they're comfortable. And so one of the things that I do when I'm local counsel, or even in cases I try now, in areas outside of where I live, is I make certain I understand the dwelling where the jurors live, the neighborhood where the jurors live, what's around the neighborhood where the jurors live, because that is a self-expression of that juror about where they fit in, from a socioeconomic standpoint, from the standpoint of how much they can afford, all those kinds of things. And now with Google Maps and other search engines, you can actually go and look at their residence if they live in a single family home. And I would encourage you to do that. Do they mow their lawn? Do they trim their bushes? Does the house look painted and well kept? It tells you a lot about that person and the way they think. And so I would really encourage you, if you don't have a lot of information, to think about a person's address. 7 of many, opening statement. You've heard all sorts of things about opening statement. Here are just kind of my tips on how the opening statement at a trial can be better delivered. Research says 58% of what that 58% of people remember what they see and hear, 32% remember what they see, and 10% remember what they only hear. So in your opening statement, show and tell. Show and tell. Use visual outlines. Make certain the court understands what you're going to use. Use outlines or PowerPoints. I think we all do that. Use pictures, timelines, show key exhibits. Do that up front. Why? Because the jury will remember it. Consider drawing on a whiteboard, drawing a scene or a graph as a lawyer during opening, if you can. It makes you the teacher. It makes you the helpful lawyer. You can go to an art museum and look at the finest art in the world, but every time that you're in an area with tourists and there's an artist there sketching on a pad or drawing with oils or doing a painting or a portrait of someone, a crowd gathers. Why? Because people are fascinated by drawings. They're fascinated by the act of drawing. So if you can do that in your opening, I would encourage you to do it because people will really pay attention to it. Take them back to the event. Tell them during opening to judge events as they occurred and to fight the notion of 20/20 hindsight. Nothing is more important than the now of being back at the accident, being back at the event, being back at the discussions in a commercial case. You have to take them back and tell them to go back. I don't think opening statement is the be all and end all that many people think it is. I don't think jurors make up their mind in opening. And I think as we evolve and have more social science available, I think most people would agree with that. But what happens in opening is the jurors put on glasses and they use the glasses as filters for what they hear in the rest of the case. And they use those lenses to evaluate everything that is said. And so what you're trying to do is to get those jurors to hear things the way you're going to present them and accept what you're going to say. How do you do it? Primacy. The first 30 seconds has to be a statement of why you're right and why you should win. That's why we have 30-second commercials now. In fact, most advertising people will say that the first 3 seconds, the images that are shown on television in a commercial setting are the most important 3 seconds to get you to say yes or no to whatever's about to come. I try to introduce a phrase that you'll want the jury to use in jury deliberations, and we're going to talk about that in a few minutes. That's an important thing that I try to do in trials. I try to tease an explanation for the other side. I try not to say they are wrong because, to the extent you can in opening, because I think it makes it too easy for the other side to combat that and deal with that during the course of the trial. And I also try to close strong by repeating that thing that I said up front. Primacy and recency. You tend to latch on the first thing and the last thing that you hear. Direct. I'm really bad at direct examination because it feels blah to me. Don't know why. But we live chronologically, so I always try to present my witnesses chronologically because we think that way. I have the hardest time reading a book or a movie that starts in the middle, where you watch 5, 10, 20 minutes and they go 3 months earlier. You think, what was that? Or it's even later in the movie. So try to present your direct chronologically if you can, because that's how people think. Again, we live in a world of pictures and video. We used to read a black and white newspaper every day. I get one at my house and my wife reads it. I read my newspaper online. We expect to be shown things on YouTube and Instagram. And so everything should be visual to the extent you can. But remember, one picture is better than 3, is better than 5, is better than 10, because one picture has more impact if it's the right picture. But again, it's show and tell, show and tell. Cross-examination. You know, most surveys say that the jurors believe what they hear on cross, but they don't tend to believe what they hear on direct. So to me, cross-examination is really important. And I find that for most lawyers, they set out trying to destroy the witness because they said something different at their deposition, darn it. And I'm going to show the jury because they said something different at their deposition that they're not trustworthy, and that never works. And we never destroy witnesses, and we always feel at the end, blah. So how do you plan a cross-examination? I do it two ways. First, and this was stolen when I was a young lawyer, I know he's controversial, but I heard F. Lee Bailey speak, and he told us these 3 points that I follow in every case. When I'm cross-examining a person, I try to establish the points the witness agrees with me on. That's the easiest. Because then in closing, say, Mr. Weston, the plaintiff's expert, even agreed, blah, 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 blah. Second, neutralize points you can, things that they may not know, things they did not do, where they have no opinion and therefore cannot express an opinion or can't express a statement of fact. That's the second level. The third is impeachment. Impeachment is hard. And most jurors, because it happens in such a small amount of time in the length of the trial, really don't pick up on it. Now, the second thing I do is before every trial, I saw a very famous lawyer from Minneapolis named Irving speak, and he wrote a book called The 10 Modes of Impeachment, The Art of Cross-Examination. There are 10 ways that you can impeach a jury, and I go through a witness, and I think about every one of these with every witness I cross-examine before trial. The first is the ability of the witness. Oath, are they too young? Capacity, are they too young or have mental infirmity? Perception, did they see it? Did they see it? One of the things I think we all realize is we seldom see events, we hear them and turn and look. I have a case right now I'm defending where a semi-truck driver said, I saw that car hit another car. And on cross-examination, I said, did you really see it, or was your view blocked by this other vehicle? And he said, I assume they hit. I was blocked by that other vehicle. No perception. Recollection or memory, that a witness can't remember the key events, can remember things that they shouldn't be able to remember, can't remember the things they could. Communication, they can't say what they saw in a good way or an effective way, and you can cross-examine them to use the words you want. A bias, we all know what these are: bias, prejudice, interest in the stake, and the outcome. An example there is I do a lot of bad faith work. So if I have an insurance executive who's testifying in a bad faith case as an expert, obviously they're pro-industry, and so they have an interest in the outcome. Unreliable, hardly ever get a great conviction that works. Prior bad acts don't work. But prior inconsistent statements is the one we latch onto. That's you said something different at your deposition. So I use this as a checklist. You have it now. You could probably get it online, but that's how I plan cross-examination. Closing argument. I've got about 5 minutes left. These themes that you're going to hear me discuss in Iowa, I try to set up during voir dire so that we can return to them. But in the 1990s, I went to a session like you're having today in Michigan, and I heard a very smart jury consultant say that the most important thing that you can do in closing is to become we have 8-person juries, become the 9th juror in the room. What does that mean? That you want the jurors who are going to deliberate to adopt the language that you use and the phraseology that you use and the concepts that you use, so that when they're deliberating, they say them. They become you. And I'll give you an example when we get there. I always tend to start off with the oath that they've taken. And the reason I do that is because they've taken an oath to apply the facts to the law, to only consider what they've seen in the courtroom, and use the jury instruction the court's given. The court is given. I think defendants benefit from the instructions. And so I spend a lot of time at the beginning of a closing argument reminding them of their oath and why their oath as jurors is so important. It empowers them, but it also says, I have a very special responsibility in this case. And oftentimes I'll tell an analogy if there's something in the news about another right that were conferred by the Constitution and how we all understand that right, but that another right is the right to be tried by a jury and how important their oath is to that system. The second thing I try to do is talk about evidence in the cart. What does that mean? All of the possible evidence at a trial is compared to all of the different things that you can buy in a supermarket. But I tell them it's only the goods, it's only the food that you put in the cart, the evidence that's in the cart that goes through the checkout line that you should consider. And then I talk about the things that have come up during the trial that are not in the cart. And invariably, after the trial, there is a juror who we'll ask them a question, what did you consider this? And they'll say, no, it wasn't in the cart. They use that term. And it might not be a cart for you. You can say it's in the box or out of the box. You can use any visual that you want, but I use this one to try to get the jury to say that when they're deliberating. I tell the jury, because it's in the instructions, to put sympathy in a jar on the shelf. And I physically in the courtroom do that and set it on the shelf. And when they're in the deliberations, invariably someone will say, I feel bad for this person, but we can't really feel that badly or have that much sympathy because our sympathy is on the shelf. I talk about proof a lot. Plaintiffs like to say 50 plus 1. They always show the scales of justice. Well, that would make it, that's an analogy that I use, is that's like saying my pile of sticks in the river is bigger than yours, when what they have to do is build a bridge of truth across the river. They have to prove the story. They have to prove the way it happened, not that they have more exhibits, not that they have more witnesses, not that they took longer to try the case. Not sticks in the river, a bridge of truth. And I think that's a good analogy. And my favorite one is, there is never an instruction in any jurisdiction that says that preponderance of the evidence, or the standard in your case, in your state in a civil case, is 50 plus 1. Doesn't exist, not in the instructions. That's not what it's about. It's about convincing you by a preponderance of the evidence that their story is accurate. Their story is the truth. If you're not convinced of that, they can't win. They can't win. Tell a story. A story has a beginning, an end. A story has heroes and villains. A story has drama, sometimes humor, but it has a moral, and it has a teaching, and it has something you take away from it. And so I would always tell a story if you can. And I'm not a great storyteller at trial. I know I look like I'm older than dirt, but I have never really been very good at that. I'm getting better because I've thought about it more. But I try cases with attorneys where I literally set down the pen because it is so interesting the way that they argue the case, because they tell a story. And I think if you have that ability, if you're a Dustin Hoffman and you can tell those stories, I encourage you to do it. Address the bad evidence and half-truths. I think we all try to do that. You have to discuss damages. I give them a logical way of calculating the damages of what I think are reasonable. I try not to give an ultimate number. That's controversial. Sometimes it can be the right thing to do if there's a clear temporal break in time where you can segregate all the damages up to a certain point and it fits your theory of the way the case happened. Sometimes you can do it, but ultimately I talk about a way to calculate the damages, if their damages are going to be awarded, based on, and give them a reasonable notion of how to do it. Show them what you want to do, tell them to say no, forecast rebuttal, because you're not going to be the last person speaking, and deal with it. Thank them and celebrate your big win because you just won. Well, that's, let's see, it's 11:41 Central, 12:41 in Michigan. Those are my 37 minutes on trying cases. There's lots of ways to do it. Those are some of the things I think about, and I hope it brought a smile to you and maybe gave you something to think about. So we've got 3 or 4 minutes for questions if we have any.
One question, Mike. What is an ideal length for opening and closing statements?
I think shorter is better. We're time limited in our federal courts. We're not time limited in our state courts. I think most people would tell you that jurors start to lose you. People start to quit listening after 15 to 20 minutes. So you either have to have a hard transition after 15 or 20 minutes or something to show them to bring them back to the beginning of the clock again, or you need to be winding down. So I always think in terms of 15 and 20 minute segments. And I don't typically give very long opening statements because I really think that you don't need to.
Okay. One more question for you is, how do you keep a juror interested in a video deposition of a doctor?
Well, it's getting better, and the way it's getting better is the video screens are clearer and better, and in many courtrooms, especially federal courtrooms, if you do things on the side, like if you have something to show, the doctor can show that on the screen and demonstrate it if they need to, and it's captured. So what I try to have them do is either show something, stand up and show something on their body, move around, or use visuals to show and tell just like we do. But you're limited by the screen. And so you can't have anything, for example, here are my notes from my PowerPoint today that I want to discuss with you. You can't read any of them. And so if it's not something you can't see, it's really not very effective.
Okay. Well, those are all the questions, Mike. Thank you so much for the very interesting presentation today. We appreciate it.
Bye-bye.
Bye. So as mentioned earlier, we are fortunate to be joined by 3 esteemed judges today. Judge David Allen of Wayne County Circuit Court, Judge James Jamo of Ingham County Circuit Court, and Judge Curt Benson of Kent County Circuit Court. We sincerely thank them for taking time out of their busy schedules to be with us this afternoon. The judges will discuss their experiences on the bench and will take some questions at the end. As a reminder, please place your questions in the Q&A box. And Ed Perdue of the Perdue Law Group will moderate the judicial discussions. Ed.
Oh, thank you. Well, good afternoon, everybody, and judges. Thanks for joining us today. So I guess to start off, it might be helpful to segue from Mike Weston's presentation and just give you all an opportunity to share with us, anything that jumps out at you as the number 1 or number 2 tips for our membership in terms of how to be effective advocates at trial. And why don't we start on the east side with Judge Allen. Any thoughts on that, Judge?
I thought you'd go with the older guys first, out of respect for age. But you can start with the handsome guy first. That's okay, and the east side guy. But yeah, some tips. And I looked down the list of participants, and it looks like a pretty good mix. We've got some veterans watching us today, and some newer lawyers as well. So probably what I'm saying might be a little old school for some of the lawyers that have been around, but for some of the newer ones, I think one of the biggest things that I think should happen, especially with younger lawyers trying cases, you need to have somebody else with you in the courtroom. Doesn't always have to be a lawyer, probably should be a veteran lawyer, but could just be somebody from the office, a family member, to watch. I think one of the biggest things we miss as attorneys is body language. you need to watch the jurors. You need to watch the judge. If I'm falling asleep during your presentation, it's a pretty good bet the jurors are falling asleep too, and you need to pick up the tempo somewhere along the line. I think body language is so critical to understand which jurors are paying attention to which witnesses, to which type of evidence. Are they shaking their head? Are they rolling their eyes? Are they half asleep? Are they, whatever have you? There's all kind of cues, and sometimes as lawyers, you're so caught up in the nuts and bolts of trying the case, and it's understandable that you don't have a third eye to watch the body language, but the really good attorneys do have that third eye, and it develops over time as you try more cases. But especially for the new lawyers, you need to have somebody that can watch folks and, write notes, talk during breaks. And really, if you're paying attention, you start to figure out who it is that are the ones likely to become jury forepersons, ones who are likely to be going your way perhaps, or maybe not going your way. So I really think you've got to watch what's going on in the courtroom in addition to all the other nuts and bolts things that are going on. One other pet peeve I have that I think I see abused a lot in trials is the Benny essay deposition. I think a lot of attorneys, especially the younger ones, take them as if they're discovery depositions. And I heard somebody talking, there was a question about making doctors' deps more interesting. I forget the exact question. But if you take a Day Benny essay dep as if it's a discovery dep and it's droning on and on and on, that's a good recipe to lose your jury with that witness. You really got to be tight with those depositions as the jurors watch them by video. But those are a couple of just quick things on my end.
Great. Thank you, Judge. Judge Jamo?
First of all, I agree with Judge Allen. You need somebody to be observant. If you can't do it yourself, to be observant about what's going on in the courtroom. Great point by him. When I sat down earlier this week and thought about some questions and some tips and wrote down, first thing I wrote down was almost exactly what Mike Weston led with. And that is, I think you have to pay attention and be aware of the fact that the jurors are hyper vigilant about watching you as the lawyer. And so what I think you need to do, like Mike Weston said, is you need to convey that you're organized and that you're prepared, and convey confidence in your position without being arrogant about it or indignant about the other side's position. So it's everything from how you look, how you react to what's going on in the courtroom. Probably many people watching this webinar have had this experience. I know I had it trying cases, as Mike Weston said, where there's a bombshell drop that you had no idea was coming, and the ability to just sit there and roll right on as if nothing has happened to upset your world, and figure out what to do with it as you go on. But the way counsel table looks, being organized on counsel table, not having it a mess. I talk to almost every juror. I know that a lot of judges don't like to do this or have their reasons, and good reasons, why they don't talk with jurors. I talk to almost every jury after a trial. Since I've been on the bench, I've done this. And they almost without exception start out talking about the lawyers. They've been talking about the lawyers from the beginning of the case. They talk about them throughout the case. They talk about them during deliberation, and then they talk to me about them. And one of the things they talk about is whether the lawyers seemed organized, seemed prepared. They do look at the table and see if it's a mess, see if they're ready to introduce exhibits, and how they present things. So I think that's a real key thing that Mike hit upon in his presentation.
Thank you, Judge. Judge Benson, any thoughts on this?
Well, heck, I got to follow up on something that Judge Jamo just said to remind everybody that yes, you're on display as a lawyer, right? And organized, prepared, and how you present yourself. But remember, You're on display beginning when you pull into the parking lot in court that morning. Jurors take breaks, they go to lunch, they come to court in the morning, they leave in the evening, they will see you. So if you're behaving one way in the courtroom, you're solemn and you're showing gravitas, and 5 minutes later you're yucking it up with your client. Not that there's anything wrong with exchanging a joke with your client. Just remember, you're always being watched. So begin your presentation as you get out of your car in the parking lot in the morning. End your presentation when you walk into your side door at your house. Don't ever stop presenting yourself well when you're in trial. That's just a follow, because I agree with everything Judge Allen and Judge Jamo said. I just want to extend it to the entire courthouse is your stage at that point. The other thing I would say, as far as, and I really enjoyed Mike Weston's presentation, talk about evidence just for a moment. We all take evidence in law school, and we've all filed and we've all defended motions in limine. I think it's a good idea before a trial, if you have time, because I know how very, very time-consuming trial prep is. But I might ask, when was the last time you actually just sat down and read the rules? There's only 65 rules in the state of Michigan. It does not take long to read them. I always read the rules of evidence before each trial, even though I feel like I know them. I feel like, oh my God, I've done this 1,000 times. It's just like picking up the rules of civil procedure as you're doing motion practice. Read your rules before trial. Like I said, there's only 65 of them. You're familiar with them. It won't take you long, but it really helps you when you're in trial to be able to remember. Otherwise, you might get something, a best evidence rule is something that you haven't seen in 15 years. It's helpful if you had just read that rule the night before or maybe the week before. So that's just a little suggestion I give, especially to the younger lawyers, but veteran lawyers too. Read them. It comes in handy at trial. And along those lines, as you prepare for trial, sort of visualize the trial and kind of walk yourself through the trial in your mind and start anticipating those objections. Because there have been times, for example, when I see an objection in court, and I'll turn to the person proffering the evidence and I'll say, what's your response? And I get kind of flat-footed, and in the back of my mind, I'm going, well, surely you knew this objection was coming. How could you not recognize it as soon as you try to introduce an out-of-court statement? Even if it's obviously not hearsay, someone's going to jump up and say hearsay. So be prepared to respond to an objection. And the only way you can be prepared is to, this sounds very zen, but, before the trial, close your eyes and imagine the trial, and you'll see the objections coming a mile away. Be prepared to respond to them.
Oh, that's good advice, Judge. Thank you. It strikes me that maybe we should move on to the flip side of this coin. And in light of what you've all just shared with us and what Mike Weston shared earlier, and ask you this, and that is, is there anything that you think counsel should never do in a trial? And, we've heard a few things about I think things that touch on that, but is there anything that jumps out at you that you think, counsel would be ill-advised at doing, yelling at their co-counsel, things like that, that would be a really bad idea in your experience? And why don't we just stay with Judge Benson since we're there with you now?
I think a mistake that lawyers make, and again, particularly young lawyers, let's go back to Mike Weston's very good presentation on, say, impeachment, a very difficult thing. And I know that younger lawyers often think of impeachment, they think of credibility. Okay, that question, credibility, they only think it means one thing. Either someone is being truthful or someone is lying. And therefore, if there's an inconsistent statement or if there's some intrinsic evidence that the testimony is inaccurate, they attack as a liar. Hundreds of people have been exonerated from death row. Many of them were there because of false identification. Those witnesses were not necessarily lying. They were mistaken. Credibility simply means worthiness of belief. There may be a witness who is testifying inaccurately. It doesn't make them a liar. So we've got some people who are just, that's it. They're either lying or they're telling the truth. No, the question is, are they being accurate? And if you lose that feel for that witness, and you start attacking somebody who clearly is not lying, but might be mistaken, you're alienating the jury. So always listen carefully to what the witness is saying. Get a feel for the witness. Is the witness bold? Can the witness take a tough cross-examination? Is the witness going to crumble? Don't always assume they're lying. You might rather gently sometimes, through good cross-examination, simply suggest to the jury that this witness, you know, I honor you for being here. You're doing the best you can, but isn't it true you're probably likely mistaking? And the jury will appreciate that, A, the testimony is not accurate. B, you treated the witness with some respect. So sometimes, yes, aggressive cross-examination is necessary because, yes, some people do lie. And yes, you can prove they're lying. But often they're just mistaken, or they're acting a little surer of themselves than they really are. And if you can bring that out without accusing of lying, sometimes that's the best course.
All right, thanks, Judge. And let's go back to Judge Allen. Any no-nos that jump out at you, Your Honor?
Yeah, one no, but I just want to say what an excellent Judge Benson. You really got to know that fine line between lies and inaccuracy, because the jury does at the end of the day, and that's really their job. And if you've come down on the wrong side of that dichotomy, it's going to come back and hurt you. And I think for the most part, it tends to be inaccuracy or misview or something, as opposed to outright lie. But there is outright lie. You got to know the difference. But my no is, and I call it, don't go down the rabbit hole. I think what a lot of plaintiff attorneys are going to try to do, and I've seen it in action, is to push the buttons of the other side of the bench, the defense bar. And I have to call out two of my favorite young trial attorneys. I don't think either one of them are here, Kyle Smith and Kelly Bennett. And they both tried different cases. And I just was so in awe of them and have such great respect, because in each of their cases, they had difficult plaintiff attorneys that were trying to push buttons. And these two never lost their composure, never, matched, the button pushing or what. The attorney was trying to get a response out of them. And it would have been fatal to their case had they done that. And I'm sitting up there on the bench thinking, boy, I really want to, slug back on that underhanded point. But you've just got to do it in a way where you're not, you're always taking the high road. I think jurors, like most people, they're looking for who's the adult in the room, who makes the most sense, who is the most rational. And if you're matching some attorney on the other side who's trying to bring you low, it just hurts your case. And I always call those two out. I have great respect for them because they just didn't let the other attorney do it, even though they had to hold back all they could to not respond what was really instinctual to respond to some attacks and such like that. So don't let anybody push your buttons. The jury's always watching you. So
Thanks, Judge. Judge Jamo?
I guess the first thing I would mention is sticking with the theme of the jurors watching you, as Judge Allen just said, and as we talked about earlier, is don't argue with the judge in front of the jury, because as much as you think the judge might get offended by it, jurors are much more offended by it than the judge is. Every time I talk with jurors who have seen lawyers try to debate something with the judge or a ruling or just something going on in the courtroom in front of the jurors are totally put off by that, and it sets you back so far in your credibility with the jury that I think sometimes you can't recover from it. The other thing is that I would mention is to sort of an offshoot of the theme that Judge Benson was talking about and Judge Allen in terms of this difference between credibility and actually lying. And this is something Mike Weston touched upon as well in his presentation, and that is you really need to resist this temptation, cross-examination, to try to impeach the witness on every little distinction between what they said in their deposition and what they're saying at trial. It never works. It just flat out does not work. The witness usually has some explanation that is plausible to the jury and falls in that area of, well, this is, you know, they weren't flat out lying. They weren't trying to misrepresent. There's some reason why there's some distinction, and it is tedious to do. It is hard to do effectively. And so you need to really reserve, and I think this was Mike Weston's point, you need to really reserve doing that for something that is really significant and is something closer to being able to prove a lie, as opposed to just, well, you said this in your deposition and now you're saying this, but it's sort of a fact that the jurors are going to say, yeah, so what? Why are we even talking about this? So I think that's a big temptation for all of us who litigate cases. It's a temptation, but you need to resist that temptation.
All right, thanks, Judge. And I want to follow up on something that Judge Allen just mentioned. So, so while I have you on the screen, Judge, what are your suggestions when faced with the scenario that Judge Allen described, where you have a very difficult or obnoxious opposing counsel that's trying to push your buttons or otherwise really elevating the temperature in the room?
I think, is it Judge Allen or for me?
That's for you, Judge Jamo.
Okay. I think exactly what Judge Allen touched upon, and that is you need to be able to stay calm and to ride through it and be very strategic about your response to it. And that is, you shouldn't be jumping up with everything the opposing attorney does and objecting to every single thing that is obnoxious or off-putting or outrageous, because at some point you become more of the focus of the jury and the disruption than the other side does. And so while there are times that you're going to need to object to things that are being said, you have to strategically figure out which battles those are to, worth taking on and make them very few. And for the rest of it, show, as Judge Allen just conveyed, show that you're the calmer, more reasonable voice in this dispute or debate. And I think it will put you further ahead in terms of credibility in your overall presentation and argument.
All right, thanks, Judge. Judge Benson, what do you think about that?
Well, I agree. And I think that we have 3 judges from east side, middle, west side of the state. And as you know, there's sort of a cultural change as you move across the state. And so what might work in Detroit doesn't necessarily work in Grand Rapids, doesn't necessarily work in Lansing. So the lawyers have to be tied to your local, or for example, I tried a case once up in the Upper Peninsula, just a different feel, just a whole different feel and a whole different approach trying a case in the Upper Peninsula versus trying a case in Detroit. So know your culture, and being obnoxious and swaggering, frankly, does not work in Kent County, and very few lawyers try it. And those who do are penalized by the jury typically. So the lawyers need to know, you can be maybe a little more aggressive in Detroit than say Ottawa County, or you might do it a little differently so keep in mind the culture of where you're trying your case. And I apologize for repeating myself, but what might work in Detroit might not work in Kent County, might not work in Ingham County. And so know your audience, I guess, is another way of saying that. Okay,
thank you. Well, and if I could start now with Judge Allen. We live in unique times, and certainly this pandemic has raised issues for all of us, but in our profession, this COVID-19 situation has made things difficult and different for a lot of us. And I want to just ask each of you, starting with Judge Allen, how is your court and in your area dealing with the pandemic? Do you see us getting back to jury trials? Are you already there? And then secondly, after giving us an update on that, can you recommend any particular techniques or tools that our membership can use when conducting Zoom trials or hearings that you found effective in recent times to communicate and advocate effectively for their clients electronically?
Okay, well, let me start first off with the disclaimer that I don't speak for my court. I'm not the chief judge. That's Judge Kenny. And as we speak currently, the Wayne County Circuit Court has put a pause on jury trials, both in the criminal and the civil division, until I believe it's January, right after the first of the year. And I think that's driven by standards coming from SCAO and the Supreme Court in terms of COVID numbers and other health statistics. So there isn't going to be anything till the end of the year. And if you were to ask me my best guess, I don't think we're going to get civil trials up and rolling anytime soon after that. Our priority in Wayne County, is maybe other jurisdictions, is with criminal because of the constitutional issues and speedy trial and such. And we're going to have to devote resources to trying trials there. We've tried 2 criminal trials in Wayne County this year since COVID, and haven't had any civil trials. Our courtrooms are set up for them. We have protocols in place. There are judges who have volunteered to do civil trials, and we just haven't gotten them off the ground in the civil division. I don't know what the first of the year is going to look like, but let me I want to give you some perspective and maybe a little bit of Judge Allen editorial that I think some of the attorneys that have been in front of me have probably heard before. And that is, in Wayne County in 2018, there were 30,000 civil case filings. In 2019, same, approximately 30,000 civil case filings. We're a busy court in that regard. And I think I'd shock most people if I told them that in each of those years, we had around 60 jury trials. So to put it in perspective, we talk a lot about trials, but the reality is, out of 30,000 case filings, somebody can do the quick math. We don't really do a lot of trials. I don't speak for other jurisdictions. And I think what that means is we talk a lot about trials, but the reality is maybe we need to talk about all the other things we need to do short of trial to dispose of cases. And because I find at the end of the day, what in most of the cases, what the attorneys need is not necessarily a trial, but a trial date and a credible threat of trial. And that's really the problem we're having in Wayne County at this point. We just don't have that credible threat of trial. Some judges are not scheduling trials. Other judges, like myself, are scheduling trials. I know folks have different viewpoints depending on their perspective of the camp that I'm going to schedule the trials, because you really need the threat of the trials, and hopefully that gets some cases settled. Others are taking the long view that we're just not going to schedule trials until we really know we can have trials. So I don't know the point of all that other than to say that we're probably not going to see trials in any great volume in the civil division for a while in Wayne County. That's my view of the horizon. Again, I don't speak for the court. As to techniques, I've had a couple of bench trials, so it'd be difficult for me to opine on techniques certainly for jury trials. I don't see that anywhere on the horizon in Wayne County Zoom jury trials. So for me to make any comment on that would really be speculation at this point, and really not based on any experience that I've had, or certainly any training. So.
Thanks, Judge. Judge Jamo, any thoughts on the pandemic, how you're dealing with it, and any particular techniques for electronic presentations, whether it's at hearing or trial?
I'll start with the techniques. And like Judge Allen, I can't give you a tremendous amount of insight. We have not had very many trials here since the pandemic as well. I have not had one. I have a colleague who has had 2 short criminal trials and another one who has had 1.5 criminal trials. And so there's not a tremendous amount of experience, but in terms of just in general, something that I think would apply for trials and evidentiary hearings, because I have had evidentiary hearings, is just a quick tip in terms of exhibits. One of the things that you might want to keep in mind for exhibits is, we found this has worked pretty well, is to have counsel send them electronically to in my case, to my court reporter, and she then marked them. She would mark them with exhibit stickers, and so they're already, pre-marked. I then can have them on my screen or have them in hard copy for the evidentiary hearing, and same for the witnesses. So I guess the distinction is, even though we're learning, all of us are learning about screen sharing documents, but this would then, you would be screen sharing or presenting a marked exhibit. And so then the court reporter has them in the record, to keep for the record, and you're already sort of off and running as far as establishing the record, as to get around the problem of not being in person in court to hand the exhibit to the judge or to the court reporter or whoever is going to be in charge of your exhibits. As to the scheduling of trials, I guess we're much like Judge Allen referenced in Wayne County, but a much smaller set of judges handling or addressing this. We are in suspension on trials, currently under an order that there will be no trials of any kind through the end of November. I expect that will quickly change to no trials through the end of the year. I just got our weekly update on our COVID numbers and how it impacts what we may do here in Ingham County, and they look terrible. The numbers, like I guess most places, look awful. And so I don't expect any jury trials soon. We have the same problem Judge Allen talked about, both in the criminal world and the civil world, of if you don't have trial dates, it's for some people, and I've been talking until people are tired of hearing me say this, that people need to get creative about how to resolve their cases. And I have more concern about that in the criminal world than I do, the criminal docket, than I do in the civil world, because I do see civil cases, we're still getting some civil cases that are settling, probably not as many as if we had trial dates that they were facing. But in the criminal world, we've almost ground to a halt here in terms of getting pleas. And what that means for the civil lawyers who are watching here is that here in our circuit, we have 4 judges who have general trial division dockets, meaning we have civil and criminal dockets. And then, one has a fully criminal docket. And then we have another judge, Judge Stokes, who has a full civil docket. For those of us who have blended dockets of criminal and civil, I have no idea how we'll get to a civil trial anytime soon, unless the judge just happens to want to drop in a civil trial at some point. But in terms of demand, we have so many criminal cases backed up. I don't even want to think about how long it will take for us to work through those. There are a lot of constitutional issues, a lot of motions to be released because of the time they've been incarcerated. And so we're going to mostly be, for most of us who have a blended docket, we'll be digging out of the criminal cases for a long time. And unfortunately, the civil cases are going to take a back seat for the most part, unfortunately.
Thank you, Judge. Judge Benson?
I've got nothing to add. The county hasn't tried a case since March. And like Judge Jamo, I'm of a blended docket. So I do criminal and civil. And my criminal, I've got it. I'd be surprised. I'm getting worried whether we'll try a civil case at all in 2021. I think that's how bad the situation is. And like Judge Allen, I agree. Really what settles cases is a firm trial date and no hope of an adjournment. that's what settles cases. So the cases aren't really settling, they're lingering. I offer all the time to say, hey, I could try a non-jury trial, and I've got a couple of those, but those are, you know, equity cases. I got a couple boundary disputes and stuff, small potatoes. I really have little to add. It's just a bad situation, and I did a lot of mostly civil litigation in my practice, and I was always kind of annoyed that the criminal stuff always takes precedent. But we all understand it does, and we all understand why it does. So we're going to be trying criminal cases off because we're not going to resume trials at least until January. And we're going to be doing criminal cases for months on end. I don't know when we're going to get to the civil stuff, frankly.
All right, so Judge, are you saying that Kent County has not tried any criminal cases this year, or any case, no jury trials of any kind?
No jury trial. What happened is we blocked off the 5th floor. We did all the social distancing. We're gonna have it like an experimental case. Judge Trusock, who's our chief judge, is going to try the first case, and it was going to be kind of a middling sort of felony, nothing too serious, nothing too like a retail fraud or something. And at the last minute, for whatever reason, the Supreme Court pulled the plug on it, and we keep scheduling stuff. For example, this week I was scheduled to be in trial, but Scale canceled them all. Kent County's numbers are shooting sky high. And so now we've suspended all trials since until January. But no, we have not tried a case in Kent County since March. Any kind of case. Okay. Except for non-jury. We have had a couple. In fact, we had a double homicide, a double murder case non-jury. But other than that, we've not really tried cases.
All right, good to know. All right, so next question I've got for you all to consider is mentoring. It involves mentoring, and I guess the question is, in your experience, is there a good way for a senior attorney to mentor less experienced counsel and get them involved in a trial without jeopardizing their client's chances at trial or putting them in trouble with their client? I know there's a fine line there, but have you seen anything or experienced anything that you would recommend to our membership that helps them, sort of pass the torch to the next generation, and otherwise get their team members some critical trial experience? And why don't I go with Judge Allen on that first?
Yeah. Great question, Ed. And I notice some of the participants, we have some great mentors that are watching right now and really need to be emulated. I know Irene Hathaway, John Sire, Brian Einhorn. These are great mentors to a lot of the attorneys, both within and outside of their firms. And I think that's one of the disappointments I have in this age of COVID, is that it makes it very difficult to mentor, especially those that are outside the firm, because we don't have our bar association get-togethers. We don't meet in the hallways outside of the courtrooms. We don't have our informal lunches within our circles where a lot of the mentoring takes place. But I think it's a critical component, not only of the trial practice, which we're talking about here today, but really the practice in general and life in general. And to the young attorneys that are on here watching this, if you don't have somebody that can mentor you, you're really missing out on a large part of the practice. And for those of you that have been around for a while and perhaps have time on your hand, it's a critical function that you pass the torch to the attorneys by way of your time and passing on your talents and insights. And I don't know how we're going to recreate that in this world of COVID. It's just really hard, us being in our own virtual worlds. And but somehow we've got to find a way to get together and have the informality that I think drives a lot of the mentorship. So,
thank you. And I was going to say to our younger participants, it's important to ask. It's important to ask if you're working with somebody senior or there's people in your firm that are going to trial. Ask for that opportunity. Ask for the chance to get in the game. And if you don't ask, it's never going to happen. So, but with that, Judge Jamo, any thoughts on that?
It bears repeating what Judge Allen just said. It is so important to have mentorship in our profession. And what you were just saying, Ed, is to ask, the young lawyer should ask, because there are very few good senior lawyers who would turn down a request to have somebody get some guidance and be mentored by them. And the only thing I would say in terms of, we can't do this given COVID, like Judge Allen said, we've lost all of this sort of outside the courtroom and now inside the courtroom opportunities. But when we get back to opportunities in the courtroom, I would say, in terms of mentorship, is there is almost every trial has at least one witness that a younger, less experienced lawyer could handle the questioning of. And so if you can think about that, find that, figure out what witness that is, and let the younger lawyers, if you're mentoring somebody, let them handle the examination of a witness. I suspect this is probably true for most of the judges on the bench, but I know personally, I am, let's say, fairly gentle with young lawyers who are taking a shot at doing a cross-examination, or they get an opportunity under the leadership of another more senior lawyer, they get an opportunity to ask questions, including if an evidentiary issue comes up and they stumble on it. I find that sometimes even a quick bench conference on it, the other side, and I don't know whether it's so surprise people or not, but the lawyer on the other side, even though they've made an objection, say, to an evidentiary point, and the young lawyer is struggling with it, if you have a quick bench conference, I find that the other side will often help and say, yeah, I'm not going to object if you just do, A, B, and C with this question. It'll cure my objection and you're all set. And I often have handled it that way. So I think there's usually, that's a long way to tell you, I think there's usually a safe way that's not going to put the client at risk at all, to allow in many trials a younger lawyer to take a shot at handling the questioning of a witness, or even part of a witness. You might find the other side and the judges agreeable to letting you break up the cross-examination if there are two very segmented parts to it, like the witness is going to testify about one topic and then clearly a different distinguishable topic that could be broken up between two lawyers if one is more in the wheelhouse of the more senior lawyer, but the other part is an easier part for a young lawyer to take a shot at.
All right, thanks, Judge. Just a reminder for our participants, if you have any questions, go ahead and enter them in the Q&A portal. Javon, do you have any questions from our members right now?
Thanks, Al. Just one question here in the chat. Do you have suggestions for effective brief writing?
I sure do.
How much time do we have?
Oh, quick tip. And this is me. I can't say it's all judges, but I know on the defense side of things, you bill by the hour or by the page or whatever it is, but you really got to get to the point. I understand you may need to take the full 20 pages to make the full point, but if you meander and it takes me to page 14 to get to your point, you may have lost me. And you have to understand your audience. Most judges, we have multiple motions a week, and you got to get to the point in the first couple pages. You can take 20 to expand on it, but my pet peeve personally is, meandering to page 15 to really get to the heart of it. Mm-hmm. And that's why I absolutely love reply briefs, because I always encourage the moving party to do reply briefs, because generally by the time of the reply brief, it's distilled down to the heart of the matter, and it just makes a roadmap for, breaking down sometimes some difficult and unwieldy issues. So
All right, thanks, Judge.
Nice.
Judge Benson?
Good point.
You know, in law school, y'all learn the IRAC method, right? Issue, rule, application, conclusion. A brief is just glorified IRAC. Tell me what the rule is. What, you know, obviously the facts, the rules apply at conclusion. Should be short and sweet. And you know, and just keep it short and sweet. What I used to do when I wrote briefs, by the way, is I would often, you know, I have a brief introduction, but I would actually have the first section would be summary of argument. And even if it's a long, complicated brief that may have taken several pages, the judge could read 2 paragraphs, and I got the entire argument in 2 paragraphs. And think of it in terms of a non-judge reading it. Like if your neighbor can understand that summary of argument, then a mere circuit judge could also understand it, okay? So consider doing a summary of argument and then go deep, do your deep dive into your research, but tell the judge really early what exactly you're arguing and why you think you should win.
Great, thanks. And Judge Jamo, you're going to get the last word here on brief writing, and then we're going to turn it back over.
Okay, I agree with Judge Benson, and it really fits with what Judge Allen said about reply briefs. They're basically, if they're good, they're basically what Judge Benson said to do in your upfront is to give a summary. I sometimes wonder when I read briefs, if the writer is worried about preserving issues for appeal. And I know there have to be, you know, you have to do some of that, but I get concerned about doing that to the extent that you make the argument so long and thick, and it comes so late in the brief, as Judge Allen was talking about, that you sort of lose track of the fact that us on the trial bench are making a, you know, like here are the 3 things we need to figure out to get this case either it's not going to survive or it is going to survive, and figure out how to get it moving towards a trial. And so, yes, I understand you have to preserve issues, but it doesn't, for me, it doesn't need to be, you know, a super esoteric, thick argument that you might be wanting to make later to the Supreme Court. We have to figure out how to get the case going one direction or another. So upfront and short, I agree.
Great, and that's really all the time we have today. So thanks to our 3 jurists. We really appreciate you coming by and taking time out of your busy schedule to be with us today. And thanks also to Javon, David, for moderating today's event, and for all our participants who took the time out to be here with us today. And I'll turn it back over to Javon.
Just want to say that on behalf of the MDTC, thank you for joining us for session 2 of the virtual winter meeting. If you can take a moment to do so, we'd appreciate it if you could fill out the survey regarding the event. A link to that survey is in the chat box. And just as a reminder, our 3rd session is being held on December 4th, and we look forward to seeing you there. Thanks to everyone who participated. We appreciate it.